And got just a little bit left to go over, just talking about litigation, and I put this comic up here because it kind of describes my feelings about it. I wish everybody could get along, but I'm a lawyer. I get paid to sue. So let's talk about litigation. First off, who can sue? Anybody can. An individual can bring a case, a corporation can bring a case, an organization. The organization doesn't have to be anything formalized. It can be just a loose association of folks. You don't have to have a 501c3. Sometimes that's very helpful for getting funding purposes, but you can just have a group of people come together and say, we want to name our group this, and these are what our goals are. And that group can challenge an agency's decision in a couple of circumstances. A couple of recommendations I have, if that's something you're thinking about doing, set out what your group's goals are so that everybody's on the same page. Figure out who exactly is in your group and set up a board so there's a decision-making authority process that your group has, so that if you're into litigation and there's a settlement proposal, you have a process for determining whether that's something you want to accept, or other aspects of continuing in litigation, making that decision. It's very important to have clear-cut decision-making process for your organization, which I've seen problems with that come up in very ad hoc groups. But there are some limitations. Anybody can sue, but there are a couple of limitations based on what has happened throughout the administrative process. If you want to bring an action, you have to have objected to the project at some point during the administrative process. That's before the project was approved. If you objected as an individual, and then once the project was approved, you decided, I want to sue, but I don't want to have my name be the named party in a lawsuit. And there's a bunch of other people that also were objecting to this project. You can form a group after the project has been approved and bring litigation in the name of that group if one of your group members objected to the project during the process. One other thing that has to have happened during the administrative process that's very important for litigation, whatever aspect of the project, whatever failing in the environmental document or approval process that you want to address in litigation, you or somebody has to have brought that up before the project was approved. If you think they used the wrong baseline, you didn't comment on it, but you see that another group submitted a comment on that, you can litigate over that issue. So that isn't individual specific, anybody, but you have to have, and the reason for this is you have to have alerted the agency what problem you think there is with this project, with this environmental review document. Give them a chance to make that change and revise the project before you can sue over that issue. There is an exception to this for categorical exemptions. If there was no opportunity to object to the project, there was no public hearing, you just found out after the fact there was a exemption approved for the project, it wasn't done at any public hearing or anything like that, you don't have to have exhausted your administrative remedies in that situation because there wasn't an opportunity for you to do so. Basics, who do you sue? The lead agency, whoever was approving the project. They are what's called a respondent in the lawsuit. And then you also have to identify the real party in interest. That's who is the recipient of the approval. In the case where it's a lead agency-driven project, where it's school district putting in a new school, respondent is the only party you need to name. Where it's a county approving some permit for a winery, you have to name the county as the respondent and the winery as the real party in interest. We've covered the 35 and 30-day statute of limitations for notice of exemptions and notice of determinations. There's also the possibility of a 180-day statute of limitations that happens when there was no notice of a determination filed, there was no notice of exemption filed, so there was nothing putting you on notice of the project approval. In those instances, you have 180 days from whenever the project was approved to bring litigation. Yeah.
Is there, within that, if new evidence comes to light that couldn't have been known at the time?
That will not, you cannot use new evidence within that 30 days or 180 days. It still goes back to the project approval date. It has to be evidence that was part of the administrative record that had been submitted to the lead agency before they approved the project.
So if you find a document in county files that no one knew about, someone did, but the planning commissioner says, I never saw it before, the public never saw it before, and it's in the record that the staff made this was many years ago, said in introducing it that there were no new documentation, and it comes to light, accidentally, a piece of paper found in a file. Is there no recourse for that?
There wouldn't necessarily be recourse under CEQA. There may be recourse under other laws for that that I'm not willing to speculate on right at this point, but it's also, there are a couple of exceptions to this no new evidence. And if there is something to, the WISPA case shows lists a couple of them that if, for example, there's something that comes to light that shows that a city council member was biased, that they were actually an investor in the project and didn't disclose that when they approved the project. You can submit that as part of your case, even though it was you discovered it after the project approval. The reason for that is obvious. They were prejudiced in making that decision and should have disclosed that, and were hiding that from you at the time.
If an applicant makes a large contribution to a political campaign, is that grounds?
I'm actually dealing with something kind of like that in the city of Palm Springs. The mayor has been on the salary of a developer as a consultant for the past 2 years. He's made, but he did recuse himself every time that developer's project came up, but he never told anybody why he was recusing himself. And they're trying to figure out what to do about that, because is it technically wrong? Maybe not, because he didn't vote, but he may have encouraged other council members and influenced their votes when he was biased in favor of the project.
But if he votes.
Only one council. Otherwise, a brown out.
Right.
We have room for him in our new jail.
Okay, a couple of, yeah.
A question. You've used this term after the project has been approved.
Mm-hmm.
What is that? Specifically, the Judicial Council in December issued an environmental impact report, the final one, for the current project for the courthouse in Monterey County. But they have not yet certified the EIR. Is the time running after they certify it?
It depends on what the project approvals are. In general, an agency will they have to certify the EIR first and then approve the project, and they'll usually do that at the same time. But I have seen instances of an agency certifying an EIR as accurate, adequate for a project, but they're not quite sure that they want to approve the project yet. And they wait until a later date to have a hearing to decide whether they want to approve the project or condition it further. And it's the statute of limitations runs from the project approval, not the CEQA certification date. Here are a couple of my recommendations if you're thinking there's a project you've got a big problem with, you don't think it's been properly analyzed by the agency, you think you might want to sue over it. what should you do? You should really figure out what your goals are for the process early in the administrative process. This goes back to, can I stop a project? No, you can't necessarily. CEQA is not going to stop a project, although going through the CEQA process may result in the project stopping. But if your goal is just to stop the project, you need to think about that and maybe have a little bit more realistic goal for litigation in that, are there some changes to this that I could accept? So really know what you want before the project's approved, and that will help you focus your comments in the process and suggest alternatives and mitigation measures. Safety in numbers, I always say, get a group together. It shows the agency. The more people you have opposing the project, the more influence it should have on them. It should have more influence when they're elected officials. The more voting people that are opposed to the project, the bigger issue it can be for them in the long run. And here's me trying to sell myself. Consider retaining an attorney as early as possible in the process. I prefer it significantly if people contact me before a project's been approved. I will also say that our firm has a higher success rate in cases where we were part of the administrative process. You don't necessarily have to have a lot of attorney work done beforehand, but it really is helpful to have someone advise you to at least an extent before that closing date of the administrative record, so they can make some recommendations on what kind of evidence you need to get in there, so they have a better record to use when litigating. And I guess I can raise this point here because we get this question a lot. Let's see. Actually, I'll address it later. Quick point on timing. CEQA cases move fast. Not like regular civil litigation. There's very sharp timelines that are set by CEQA. And usually the trial level is completed 9 months to a year. There's mandatory times for getting the administrative record prepared, and then you set schedules for briefing, and it all goes quite quickly. And the intent of that is, get this figured out because someone's waiting on the CEQA litigation before they can go forward with the project. And one very important deadline in the CEQA process is CEQA requires that you request a hearing date in writing within 90 days of filing a petition for writ of mandate. And that's what the CEQA lawsuit is called. That is a hard deadline. You have to, it's a very easy thing to do, but you just have to have requested a hearing date within that time frame. Okay, this is where I'll address it. So litigation expenses, what comes in? There's court filing fees. These are usually a couple $100. Preparation of the administrative record can be fairly expensive, depending on the size of the record. We're involved in some litigation over high-speed rail, which the volumes and volumes and volumes of the administrative record are tens of thousands of dollars. We have some other cases where it's a simple categorical exemption or even a negative declaration, and you've only got like 1,000 pages of documents. That's not, 3 volumes, really short, not very expensive. And then there's also attorney's fees. And there is the possibility of recovering these. I know this comes up a lot. We always are asked about recovery of attorney's fees. And if you are a successful petitioner, you do have the ability to potentially obtain your attorney's fees from the other side once you've been successful. If you are not successful, if you lose your CEQA case, the other side can obtain their costs from you. If they prepare the administrative record, they can obtain the costs associated with that, which is why I always recommend CEQA petitioners prepare the record themselves. It helps you get familiar with what evidence is in there, and it really cuts down on costs. And then their filing fees and such. The unsuccessful petitioner could be liable for those. And that is just my quick overview. If anybody has any more questions on litigation, I know that was a very brief overview.
Do you ever take cases on contingency?
We have sometimes in the past. It's fairly rare, and we generally at least require costs, out-of-pocket costs, to be covered by the petitioners. It often depends on what's the resource that's being protected and what's the likelihood of success. If it's a really strong case, we're much more likely to feel confident that we may be able to recover our fees and can negotiate more on the cost.
I just had a question for all of the panel. In sometimes people who apply for projects and stuff like this will overestimate, let's say, put a big number out and say, we want this for our project, like visitation or something. And then they will come back and say, okay, well, if we'll take 50% of what our initial estimate was. And then I was curious when you were discussing alternatives to projects, and you talked about the economic viability of the project. So have you ever seen this type of strategy used where they will overestimate the size of the project and then be able to say on an alternative to come back and do it? I mean, you mentioned, let's say so many tons of carbon that go into the atmosphere and stuff, and say, well, instead of 100, we'll give you 50. I mean, but it's still over 10. And so, I mean, is this type of jockeying is done there?
I would say a lot of smart developers do that. They propose something massive that nobody wants, and then they do an alternatives analysis that includes a reduced density alternative that really does reduce the impacts of this massive project that they never really intended to go forward with in the first place. But even in that instance, with the reduced density, if the reduced density is still going to have significant impacts, you should be proposing other alternatives that would really reduce those to hopefully an insignificant level. And CEQA's substantive mandate doesn't allow them to even approve a reduced density alternative if there is another alternative that would substantially lessen the impacts.
Yeah, that was my next question.
Mm-hmm.
Thank you for answering.
If there's an overriding, are there any objective standards to determine the benefit to the community which underlies the overriding?
No, that's a very subjective determination. It just needs to be supported by substantial evidence. So they can't just claim, unlike the example I gave earlier, that it's going to produce all of these jobs, but when in reality it's going to result in 5 jobs 2 times a month. So there needs to be evidence to support whatever benefit they're claiming. But the agency gets to decide what it thinks is a benefit.
So you could sue over that.
If they didn't have evidence to support it, yes, you can. Yes, thank you.
Amy, in your experience, where does a THP fit in the EIR timeline normally?
Well, they can do a functional equivalent of an environmental impact report, so they don't have to call it an EIR, but they still have to analyze the impacts and alternatives and whatnot. So approving it's the project approval, and they need to have done analysis before they approve the project.
Okay. Yeah, that's what I've been learning. But in the city of Calistoga's case, there was a large project approved, and now it's 3 years later, and they're trying to get a THP for the project approved by CAL FIRE as the agency.
Well, that doesn't sound right.
I know. I've heard this from a couple of different legal professionals, so good luck. It's curious.
Yes,
Okay.
yes. Anybody else? Questions for me? Yes? All right. Thank you, everybody. I really appreciate that you had a lot of great questions and you were so engaged in this. I know it's